that what about a president who commits murder, or if she jeopardizes national security, or if he obstructs an investigation or a white-collar crime? How do you differentiate between these crimes when you characterize them as dastardly?
The proposal for to be considered, it was not a constitutional position. I did not take any constitutional position on the issues you're raising. I want to underscore that. And if a constitutional question came to me, I would have an open mind and decide that. High crime or misdemeanor?
I'm asking about your position that you stated in this Law Review article that a president should be not subject to investigations while in office.
But the dastardly comment...
Are you you're only saying that they should be subject to investigation as part of an impeachment, and that there's no other investigation that could occur? Is that
No, I was, first of all, on constitutional position on criminal investigation and prosecution. I did not take a position on the constitutionality, period. On the idea that I talked about was something for Congress to look at if it wanted. So that's point one. The point two is the idea that at the what is an impeachable offense, and that really is a question for the House and the Senate.
This president ran for office with an instinct to demonstrate self-reliance, and she decides that they won't be a part of any motorcades. They're going to drive themselves, and they're drunk one night, and there's a motor vehicle homicide committed by the president. That's both a criminal and a civil matter. Is the president immune from either being sued or being charged with a crime because they're president?
No, no one has ever said, I don't think, that the president is immune from civil or criminal process. So immunity is the wrong term to even think about in this process. The only question that's ever been debated is whether the actual process should occur while still in office. That's the Jones v. Clinton case, where strong arguments were presented by both sides, and the Supreme Court ultimately decided that the civil process could go forward against President Clinton. President Clinton was arguing that the civil process should be deferred until after he left office. The Supreme Court rejected that. So too, the only question with the criminal process is not immunity. That's the wrong term. It's timing. And as I've said, the Justice Department for 45 years has taken the position that the timing of the criminal process, a criminal process, should be after the president leaves office. Now, so I can seize steel mills, and that didn't work by a 6-to. Immunity is not the correct word, and I don't think anyone thinks of immunity. And why not? No one's above the law. And that's just such a foundational principle of the Constitution and equal justice under law, and that's what Hamilton was concerned about in Federalist 69, and that's what the framers were concerned about. Even with having, if you read the Constitutional Convention debates, even with having a single president, they were concerned, well, that may seem like a monarchy, and that's why Hamilton felt the need to convince the people, no, this is not a monarchy. Versus Jones case, civil process, so that's a precedent of the Supreme Court on